Right, we're going to look at health and safety. Health and safety is one of the key roles where why you have fitness instructors is to make sure everyone is able to train safely in the gym, use equipment. It can be slightly dangerous if used incorrectly, and can be unhealthy if it's not cleaned properly, etc. So this unit is quite interesting. It takes into account all of those things. Just outline what we're going to learn. We're going to learn rights and responsibilities for the employer and for the employee. We'll look at the term duty of care, which is often used in this field. We'll look at regulatory requirements and describe what will happen if you don't follow the legal requirements. So obviously this is quite important. So a few things for you to think about before we crack on, so you can think about why is health and safety important in the workplace, particularly in the gym scenario. You can also think about what you might do there. But one of the drivers here is the Health and Safety at Work Act. So people do kind of take the mickey of health and safety, but before that, a lot of businesses were actually quite dangerous, and there were a lot of deaths at work. And nowadays there are far fewer. The way the Health and Safety Act is arranged is that the employer has a duty to take care and not endanger themselves and others, and also to cooperate in meeting the standards. And so they have to make sure their workplace is safe, that the systems of work are safe, and that the provision of information is safe, and any employees are instructed and trained and supervised. So it's quite overreaching. It's also quite cleverly written in that nobody's really exempting responsibility. So although employers have to do stuff, the employers have to be aware of their own health and safety and anyone around them. So if you want to have a look on page 4 in the green section in your manual, you'll see some employer responsibilities, and you'll also see some employee responsibilities. If I was you, I'd pause them, just have a think about yourself first. And then if you look on page 4, you'll see it's the employer responsibilities are to have things like risk assessments in place, provide guidance for training, to report injuries, to display health and safety statements, to provide facilities and equipment that are used. And employee responsibilities are things like following any training that's been done, taking care of their own health and safety, and taking care of the health and safety of others, cooperating with any employer strategies, explain risk control, provision of maintenance and any necessary equipment. So this is a key part of your role, to be involved in the health and safety in your workplace. In terms of rights, everyone, through the Health and Safety Act, everyone has a right to work in a safe environment. So obviously you also have a responsibility in order to maintain that safe environment, but basically until if the environment is safe, you are able to not work there. Let's have a look at duty of care. So definition is a duty of care is the obligation to apply a reasonable level of care towards an individual to avoid injury to that individual or their property. Obviously reasonable is one of those words that can be interpreted, but it is there that it's the best of your knowledge and ability, taking all the necessary precautions to minimise risk. So generally, even if it's a small risk, we generally want to minimise it. You can't eliminate all risk ever, but we do want to maintain that. So duty of care is a key thing. How do you adapt your practice to make sure that people are generally not at risk or in any danger during exercise? It's good to think of your role boundaries here. So there are you can think of some different job roles within the workplace. You could talk about a manager, an instructor, or an operational role. You get things like operational managers, etc. And you can then consider how they go about carrying out their role, ensuring that the duty of care is provided. You'll get some examples on page 5 of the green section in your manual. So one of the requirements of the Health and Safety Act is to conduct risk assessments. and this was further updated in the Management of Health and Safety and Work Regulations in 1999. So not only do they need to conduct risk assessments, but also to produce documents to underpin safe working practices. So these are emergency operating procedures and normal operating procedures. So this involves identifying risks, and as well as identifying risks, you will also try and put a value on that. So how likely is that risk, and how severe is the outcome if it does occur? Once you've done that, you should put in measurements to minimise the risk as far as is reasonably practical. So this is why you see colour tape on things, signs saying this tap is hot, signs that tell you to go slowly or to mind your head. These are all things that are trying to minimise the risk, because as much as possible we don't want people to do those things. And they should feed those then into normal and emergency operating procedures. So obviously the risks will be specific to your workplace, and that's why you may need things in your own normal operating procedures and emergency operating procedures to deal with these things. Key requirement is RIDOR. So RIDOR is the Reporting of Injuries, Diseases and Dangerous Occurrence Regulations. So these came into 1995. The idea is that anyone around the country must report if there's certain serious things happen, and that allows public health people to put in strategies if there's something like an outbreak of infection or things like that. So if any of the following occur in your workplace, it must be reported to RIDOR, all right, or to the Health and Safety Executive. So a death, any major injury, something like significant fractures or burns or anything that requires hospitalisation for 24 hours, or over 7-day injuries, so if someone's off work for 7 days, any of these things must be reported. That enables the Health and Safety Executive to say, right, listen, there's been a number of incidents in your building, therefore there must be an issue, we must come and have a look at it. Or an outbreak of infection, for example, they're able to pinpoint where the infections come and how they've come out. And it's actually criminal not to report any of those things that are reported under RIDOR. Other legislation, so legislation is a law that Parliament has passed. First aid at work, provision of work equipment regulations, electricity at work regulations, health and safety regulations updated in 96, working at height regulations, workplace health and safety and welfare regulations in 92, manual handle operations in 92, Employees Liability Act in 1969, PPE and work in 1992, the Health and Safety display screen in 92, and the Children's Act in 1989. So obviously that refers to younger people, but as you can see, there are a plethora of regulations that need to be adhered to. Most of the things in them are relatively straightforward. You'll have seen these things in operation, but it is important to make sure you are adhering. So just have a think, what do you think some of the consequences might be if you don't follow all the legal requirements? Pause this and have a think, and when you're ready, unpause. So you can see there's a case study you can have a look at on page 6, but generally you may find yourself liable for incidents and accidents, so liable either through public or criminal law. It's the duty of care is put into question, it may end up in a court of law. Any relevant documentation can be used. So if you haven't got risk assessments in place, that will be noted. If the risk assessment is wrong or inaccurate, or the documentation is poor, that will go against you. So that when you're in court, the court will consider two things: what is the standard of working practice within the industry, and what is the chain of responsibility to highlight areas of failure. So if you haven't got anything that's going to spot weaknesses, they will highlight that. So example of negligence may be not knowing a participant prior to exercise who has contraindication. So if you haven't screened, if you haven't done your PAR-Q, someone comes along and they have a health event, they have a heart attack or something whilst you're training, you haven't checked that they're safe to train, that will be an example of a negligent behaviour. So that's why we do those forms, and the forms are kept safe. So knowing this stuff can help you maintain a nice, safe business and perform your role well. So hopefully now you understand the employer rights and the employee rights, what duty of care is, legal requirements, and then also what might happen to if you fail to follow the legal requirements.